Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Oh no. Testing podium. Testing plaintiff's lavalier.
The first matter before the courts is BCD 24-172, General Holdings versus USA Metropolitan Tax Credit. I see counsel are present. I would ask that you introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Yes, yes, Your Honor. Thank you. John Campbell, representing 8 Penn Partners LP.
James Pollock, representing the Appellees, General Holdings, and Preservation Holdings.
Thank you. We are being streamed live on the web. I get a nod from that every time since we've been struggling with that. That's both by audio and by video. And Mr. Campbell, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. May it please the court, I'm John Campbell, representing 8 Penn Partners. This case is about an effort by a creditor, which is which is General Holdings, interloping into 4 limited partnerships, attempting to invalidate a long settled sale by the original investors, the metropolitan entities in the caption of this case, of their limited partner interests to 8 Penn Partners. The sale was agreed to with consent of all of the original parties to these 4 partnerships, which partnerships have existed since the 1990s, and the partnerships developed various apartment complexes in Pennsylvania. As I said, Pam Gleichman was the original founder. She found these investors. They all put up hundreds of thousands of dollars to build the projects, and by about 5 years ago or 6 years ago, they wanted to sell their interests. They contacted the only person they ever dealt with, which was Pam Gleichman, and they got their consent from Pam to the arrangement under which the interest would be sold to 8 Penn Partners, which consisted of Pam's husband as well as 2 sons and a loyal business person in the companies. The attempt at upsetting this sale is by Pam Gleichman's daughter through her company, and her company never got permission from the limited partners or the general partner, Pam Gleichman, to enter as a general partner, to become a general partner in these projects. Judge Duddy correctly stated that most, if not all, of the facts, the relevant facts, are undisputed. What is disputed are the interpretations that he put on 2 sections of the 4 limited partnership agreements.
Attorney Campbell, I see that the green light is on here, so I just want to ask a few questions to maybe try to boil down this seemingly complex matter to its essence. And by the way, I'll commend both counsel. I thought your briefs really did an excellent job of trying to boil down the essence of what's going on here. If an observer is looking at this from maybe 30,000 feet out, I think they would see this. They'd see a limited partnership here created by an agreement with express terms with 2 general partners, one being Pam Gleichman as an individual, and one Gleichman and Company, which is a corporation. Am I correct so far with that?
Yes, that's correct.
And obviously those 2 partners were entitled to manage, operate the company, and their consent would be necessary down the road if any aspect of the limited partnership interest was to be divested. So you have 2 going there, and as we know, in the meantime, what occurred was that Gleichman and Company, which was later called General Partners, I'll use General Partners from here on in, but we'll know we're talking about that same corporation, was foreclosed upon and acquired by Preservation Holdings. Am I correct so far on the facts there?
Yes, you are, Your Honor.
Okay, so a casual observer might look at that and say, okay, 2 general partners, each is required to consent to divesting limited partners' interest. And they would look at that and say, okay, individual, Pam Gleichman, yet she gave consent. Now the other partner here is General Holdings. It's a corporate partner, which wasn't even consulted and wasn't even contacted. So I think that steers us, according to your argument, to Article 6.01. I just want to ask you a couple of questions about that. Actually, I'll ask you 3 questions. And I'm going to ask you to answer yes or no, because I think a lot of these answers you would say yes, but, or no, but.
All right.
So what I'll do is I'll just ask you first the questions, and I'll circle back and let you elaborate. So my first question is, did General Holdings sell any of its interest as a general partner to another entity? The answer would be,
Did it
want me to do that again?
sell?
Did General Holdings sell any of its interest as a general partner to another entity?
It transferred. It did not sell.
Okay,
It
can you answer that yes or no?
All right.
I know
did not
what you
sell
want
it.
to say.
It did not sell them. It was at an
Okay.
auction. Yes.
Did they transfer any of its interest as a general partner?
They did transfer interest to at an auction sale. Its interests were purchased.
All right, you're not going to answer me yes or no, so I'm
no.
just going to warp ahead here. I'm going to say that on the face of it, that General Holdings didn't sell anything, didn't transfer anything, or didn't assign anything of its interest to a general partner. But what you're dying to say is that they somehow handed this off to Preservation Partners, Preservation Holdings.
At an auction, yes. I mean, that's exactly how Preservation Holdings became involved.
But there was nothing voluntary about that. Obviously, the foreclosure takes place, and you're there as the person being foreclosed upon. Somebody buys it, and off goes your interest. There's no voluntary aspect to it.
Oh, I agree. No, well, in fact, but that's why I've cited all the cases that's in the statute, the limited partnerships uniform limited partnership statute in the case law that say that transfer, the word transfer, Black's Law Dictionary says the word transfer means by operation of law or voluntary transfer. So I think the case boils down to really that simple matter, which is, I think, is all the law that I could find.
But just as a side point here, the Uniform Limited Partnership Act doesn't apply here because this limited partnership was created well before the act was implemented.
Yes, I agree. In the case law, I'm just suggesting that the policy generally is to protect entities. I mean, that's why I spent a lot of time in my briefs identifying the case law and the statutes, which in current statutes that suggest that a major goal is to make sure interlopers don't come in and take over entities that are ongoing.
All right, well, just go with me on this one here. General Holdings was still on the books as being a general partner at that, even after the foreclosure sale, correct?
That's correct. Yeah.
And your point is that the corporate ownership of General Holdings had changed, and that the new owner of General Holdings was kind of adverse to your client's position, correct?
Yes.
But again, from 30,000 feet, General Holdings is still a general partner and must be consulted on a divesting of the limited partner's rights. And your answer is no.
That is the complexity is that it wasn't an individual. It was a company that was transformed into a new ownership. That is what makes it a little difficult. But it seems to me that the policy should be the same. The partnership agreement says if more than 50% of the ownership transfers from one person to another, that has to be consented to by the limited partner.
Let me just to follow up on that, I think if, let's say Preservation Holdings came in and said, okay, we're now a general partner here, it would be impermissible because it hasn't been consented to. But this isn't Preservation Holdings coming in. They have acquired a limited partner that existed previously, and nothing really has changed. I totally agree with you. You don't want interlopers coming in saying, I'm now a general partner here, and you need to listen to my preferences on decisions. But it's still General Holdings, the corporation, that is a general partner.
But it's tantamount to the same thing. When a new person takes over an entity, it's tantamount to a new entity coming in. In fact, the partnership agreement actually contemplates that by talking about 50%. As soon as more than 50%, takes control, then it should be considered a new partner. I mean, that's the wording.
So
of the
when I go on to some different provision or a different aspect of it, so on 6.01A, there's no question that General Holdings did not consent to the transfer to 8 Penn, correct?
General Holdings did not consent.
There's no question
That's
about it.
correct. They
And
wouldn't-
do you agree that at least on its face, 6.01A would seem to require that General Holdings, as a general partner, or in the other, that the General Holdings consent was indeed required for the transfer?
On its face, it would seem
Okay.
that way, but
And your position, I just want to make sure I understand, is the reason that General Holdings consent was not required for that transfer to 810 is because since the transfer of the ownership of General Holdings was happened, then and no consent was given to that transfer, that General Holdings has only an economic interest and not a management interest, and therefore consent is not actually required. Is that?
Yes, generally, and that's the position that the people from the investors took. They say we have particular people that we recognize as the people we did business with, and unless there's a written consent to do business with some other entity, and that would be Rosa Scarcelli or Preservation Holdings, they felt they did not have any obligation to consult with her, and they consulted with the only person that they'd ever dealt with, which was Pam Gleichman. And so we think that in light of the fact that this creditor, which was Pam's daughter, took over the business without consent, without going through the formalities of trying to get consent from her
As a
mother, she
practical
probably wouldn't have
matter,
gotten.
on those facts, putting aside the family dynamics and everything else here, if it's essentially a hostile takeover by a creditor, there's never going to be consent.
Exactly. Well, I consider it a hostile takeover, yes, and that it should not be recognized. And I raised estoppel. I mean, if there's different ways to address it. Certainly a hostile party taking this position and trying to take control of an entity should be stopped from.
But doesn't 6.01A refer to the obligation of the general partner? In other words, if the general partner, isn't that at least a reasonable interpretation that if the general partner wants to withdraw from the partnership or sale, transfer, or assign the interest, that general partner must obtain consent? It's not really the new person coming in, right? And when the general partner was not doing this, and General Holdings was not willingly, if you will, giving over its interest to Preservation Holdings, why would it ever obtain a consent in a situation like
Well,
that?
a creditor, it should have, if it was foreclosing on Pam Gleichman's stock, if it really wanted to take over management interests, it should have gotten the consent. A creditor should have gotten the consent, and sometimes that might actually happen. Usually it wouldn't happen.
Probably not.
Probably not happen here. But that's the flaw of, that's the reason why an auction by a creditor isn't exactly an effective means of collecting your debt, oftentimes, and that's the purpose of the law,
But
is
it
to make
doesn't
sure
say-
entities aren't upset.
But that provision doesn't say that the incoming holder has to get consent. It says the existing general partner must obtain consent before transferring.
Yes.
But the general partner didn't have any option.
Well, I think what that means in this context of taking over control of an entity means that the creditor, in order to get the rights of management, has to get permission from the other parties. And that's the entity protection goal of these laws, is to make sure that they aren't taken over without consent. And in fact, it wouldn't have happened. They wouldn't have given consent. You can do an auction and get the stock, but that doesn't mean you'll become the manager of this entity. You cannot. There's a policy there of avoiding interloping creditors taking over.
Thank you.
Thank you.
Mr. Poliquin?
Thank you, Your Honor. To answer Justice Meade's question, the answer is no. There was no transfer of GP interest at all. General Holdings, other than a name change done by Pamela Gleichman before the foreclosure of the shares, what occurred in that transaction was a foreclosure of the shares of General Holdings. General Holdings was a partner since day one in the 90s or 80s, and it's a partner today. And recognized it. So there's no issue here. Didn't consent to becoming a general partner. It already was a general partner and always was a general partner. The issue is whether the events caused it to just go poof with nobody saying anything or nobody doing anything, or whether, no, that can't happen. And so basically, a couple other preliminary comments. Richmond isn't, even though they're a name party, the U.S. Metropolitan Fund is essentially funds run by Richmond. We call them Richmond. Richmond was the limited partner. Richmond doesn't care. They didn't participate. They didn't answer the complaint. They didn't deny any allegations. They didn't appeal, even though it says on appeal by the U.S. They're not appealing. They're perfectly happy. And what APEN is complaining about is the legitimacy or effect of a transaction that occurred years before APEN even existed. APEN didn't even exist until 2018. And APEN wants to have standing when the limited partner, Richmond, doesn't care. Richmond's never asserted in any proceeding that its general partner, General Holdings, which, by the way, dealt with Richmond for years and years, and even after these transactions, the record is clear, Richmond agreed on these other four to transfer those LPs to the Promenade Trust, with General Holdings being the GP that authorized it. And so APEN seems to believe that it can just pretend it's Richmond and make arguments Richmond had or didn't have.
Attorney Pollack, when I see the greens on,
Yes.
the Maine Uniform Limited Partnership Act doesn't apply here because it was enacted after this partnership was created. Is that correct?
Well, certainly the recent versions. I think Maine might have had original, I'm not sure when the first Limited Partnership Act was passed, but certainly not the last two or three versions are post-date the formation of this partnership.
Well, if it did apply, would you agree that your position would be weaker than what you're dealing with here today?
I don't think so, because obviously you go to the agreement. One of the things that makes these limited partnerships distinct from almost any other limited partnership issue you might get before you in terms of the right to choose your partners and all that, these are subsidized housing limited partnerships that are regulated to the hilt. And one of the things that's just being ignored that Judge Duddy didn't need to get to because he was trying, because there's 3 or 4 other pending cases, to just deal with what he needed to deal with and moot other issues. The partnership agreement itself says unequivocally, and the loan agreement incorporated in it says unequivocally, that no partner can withdraw, no partner can terminate its interest, general partner, without the prior consent of rural development, RD, the successor
Can I
to
just back you up
FMHA.
for a second to the Uniform Limited
Yeah.
Partnership Act? I mean, if it did apply, and we assume that Preservation Holdings is in fact a transferee, regardless of how the interest got transferred, the Act says, a transfer does not, as against the other partners or the limited partnership, entitle the transferee to participate in the management or conduct of a limited partnership's activities. And it says basically the purchaser to foreclose or sell has the rights of a transferee. That seems to
That's a reference. That's a reference to what happened to Pamela Gleichman, a foreclosure of her partnership economic interest.
Right.
The partnership economic interest, no partnership interest of General Holdings was ever foreclosed upon.
But her interest in General Holdings was transferred, and your client purports to operate under that umbrella of owning.
But the provision that is common with respect to saying when someone forecloses on a partnership interest, it gets the economic interest and not the non-economic interest. This is a foreclosure on shares of an entity. It's not a foreclosure on any partnership interest. So that provision isn't even applicable. Now, that doesn't mean that a foreclosure on the shares of an entity partner that was previously the partner, general partner, after there's a general partner, no transfer of partnership interest involved at all. just the shares of the corporate general partner, that provision has no applicability to that. Now, that doesn't mean that you
Wait a
can't
minute,
address
aren't
change
the
of control.
shares in the corporate general partner an interest in the corporate general partner?
It's an interest in the corporate general partner, but not an interest in the partnership.
Right,
The-
but the language, let me bring you back though, because the language of 6.01A doesn't talk about interest in the partnership, it talks about interest in the general partner.
Oh, yeah, that's why I was moving from the provision. I wasn't saying that a partnership agreement can't address a change in control of a general partner, because obviously it does. And then the question is, as Judge Duddy found, that is that limited to voluntary, or does it include both voluntary and involuntary? He found it ambiguous because of a lot of language in there that is indicative of a voluntary transaction only. So in finding it ambiguous, contrary to the statement made in the brief that he didn't rely on any extrinsic evidence, Judge Duddy expressly said that he was relying on the evidence presented at trial to help him interpret that provision. Under Rule 52, there was no request for additional findings to say, well, what evidence was
Is
that,
that
just
the
by
crux
the
of
way?
it here, that this was a judgment entered after a bench trial, as opposed to, for example, on a summary judgment?
Yeah, exactly. And so basically, and that's why I focus on Rule 52, he expressly says he resolved that ambiguity based on the evidence at trial. What could that evidence have been? You have to assume, without an additional request for findings of fact about that, that if the record contains anything along those lines that would justify it, that's what he found. What would justify the belief that the general partners don't think it applies to involuntary? Because after that foreclosure sale, everybody knew about it. Pamela Gleitman certainly knew about it. It was her individual shares, not partnership interests, that were foreclosed on. Richmond knew about it. It was in all the audits. Richmond, once discussing it with Pam Gleitman in 2018, is trying to learn more information, as is clear from the record, from General Holdings. The general partner has dealt with for years and continued to. What's going on? And General Holdings was saying, oh, well, we think her interest has been foreclosed on and she's gone, and you should be dealing with us. Never telling General Holdings, oh, by the way, we're working out a deal here with Pam Gleitman. What is clear is Richmond, as all these investment partners, as soon as they can get out of these projects and have reaped all their tax incentives and benefits, they get out of them for next to nothing. They're in the business of making investments to get tax benefits. It's all structured that way. Then they want to get out. Richmond could care less who gets their interest, and they knew that the chances of Pamela Gleitman, 8-Pen, and Rosa Scarcelli, General Holdings, agreeing that 8-Pen, a Carl Norberg, Pam Gleitman entity would be the limited partner, was zero. So what did they do? They just march on, do the transaction, put the onus on consent on 8-Pen, and they have nothing to lose. What's the worst that happens? It's invalidated.
Now, the plaintiffs here, as I understand it, have withdrawn count 2, the request for injunctive relief. Is that correct?
That's correct, because at that time, the reason that that's distinguishable is because at that time, Richmond had still possessed the other 4 and was arguably going to convey them to 8-Pen. And that was the reason for seeking an injunction. Once Richmond said, we don't care what happens here, we're not going to participate. Oh, and by the way, as it was a testimony at trial, they've subsequently sold their other 4 LP interests to the Promenade Trust, Richard Olson, under the authority of General Holdings, signing the documents. And so it mooted needing to get an injunctive thing. And what's significant here, too, this isn't an order that says 8-Pen convey these back to Richmond. It says there's no transfer ever occurred. There's nothing to convey back. There's no conveyance needed at all. It declared it a non-transfer because General Holdings' consent was not requested. Richmond's never attempted to remove.
Well, the appellees have sort of suggested that there's some uncertainty looming in the air here, and the judge didn't address some issues that are necessary.
I mean, well, they keep saying, well, Richmond's entities, these tax funds, that they dissolve. Well, one of them isn't really dissolved, but that's a Richmond issue. Richmond doesn't care. They know that if this is upheld, the day after, if it's necessary to reinstate one of these funds for a day, to sign a document over to the Promenade Trust, it'll happen. They have no, this is not 8Pen's trying to pretend it's Richmond, raising issues Richmond does not have. And as to this $13,000 dollars that was paid by 8Pen, they could have brought a claim against Richmond for that. They chose not to for one good reason. They knew that they had misrepresented to Richmond significantly what was going on, talked Richmond into doing it and taking the risk, and the last thing they were going to do is bring a suit against Richmond to get their $13,000 back if no transfer actually occurred.
Now, when you
They can do
withdrew
it
your,
tomorrow if they want to.
when you withdrew the request for injunctive relief, which obviously is equitable relief, did that have any effect? I'll just invite you to comment on the unclean hands arguments that are floating around here, and whether or not the fact that you released your action in equity affected the application of unclean hands. Is it something we need to talk about here today?
No, the clean, well, obviously that's like an abuse of discretion thing. They were complaining, 8Pen's complaining about this being filed after this 2020 settlement. And as Judge Duddy notes, well, General Holdings, 8Pen, Richmond, none of them are even parties to the 2020 settlement. They're not even in there as a party to the settlement agreement. What was going on, and as Judge Duddy said, with respect to that particular issue, clean hands and who's playing games or doing whatever, as he said, it was me, and the letters in the record, had been requesting the transactions, the documents that reflected these supposed transactions that occurred in 2018. They refused to give them to us. So we had no way, and that was even true up to the 2020 settlement agreement. We're saying we learned about it the next year in 2019 for the first time. They say, well, give us the documents. Let us see what they are. Who did what when? Refused. And that's what Judge Duddy is referring to when as a significant element of rejecting the notion that somehow we secretly hid that there was a dispute here until the 2020 settlement happened and then sprung it on them or something.
Yeah, that seems to be the underlying
Well,
theme.
there's a zero,
Okay.
a zero to that, and I think Judge Duddy, on a lot of issues, he addressed quite quickly and succinctly, and could have probably elaborated a lot with respect to that. But obviously, his judgment as to whether there was any chicanery going on to induce Pamela Gleichman to enter into the 2020 settlement agreement and secretly keeping an intent to file this suit, there's nothing, there's no merit to that, which is what he found. If one of the things that I think is obviously the threshold question is whether the provision they're relying upon applies to involuntary transfers as well. Somewhat ironically, the 100% involuntary transfer of Pam Gleichman's economic general partnership interest in the foreclosure of all of her economic GP interests, according to them, apparently has no negative effect on her. She just continues to be the GP with not any effect on her. She's the one who signed those Richmond documents in 2018 after the foreclosure of 100%. So if that applies to involuntary, why doesn't it apply to her?
Just out of curiosity, after the acquisition through the foreclosure, I don't know if it appears in the record or not, I didn't see it, but did the management scheme for General Holdings change? I assume somewhere in that corporate structure, Pamela must have been the active decision maker. Do you know if the corporate structure changed within General Holdings after the
One of the things, there were technical changes, but they were more form over substance for the simple reason that the complex history of this, and this is all in Judge Duddy's findings as well, when Rosa Scarcelli was induced to get back into the business, largely because of a lot of regulatory authority problems with Pam Gleichman, which are replete throughout the whole record. And when she got back involved, an issue started to arise in 2008. She insisted that she was going to be on the line here with the regulatory authorities for having everything be on the up and up, which historically it wasn't, she'd be a vice president of Gleichman & Co. A unanimous consent was signed by Pam Gleichman in 2008, giving her total authority over management. And it's Rosa Scarcelli that had all that authority in 2008.
But I guess that's all moot, because I think the parties agree that General Holdings did not consent to the transfer. There's no doubt about the fact
Oh, the transfer, no one doubts that not only did they not consent to it, it was intentionally kept secret from them in 2018. I mean, that's not even a doubt. And so even if the court says that even if the court says that it applies to involuntary, Judge Duddy's absolutely correct that Richmond had then the right to do something. They never did.
Thank you.
So that ends that issue. Thank you.
I'd just like to respond to a couple of these points, and that is that the suggestion that extrinsic evidence comes into play here is just, if you examine the reasoning, it's just not correct. It's purely a matter of contractual interpretation.
Do you think there's any ambiguity in the language that the judge said that is ambiguous and I need to get extrinsic evidence? Do you think that we can just rely on the plain language?
I think you rely on the plain language, and I think he did too. I don't think he pulled off any interpretation. For example, did Pam Gleichman have an opinion about what she drafted way back? She really didn't, and nobody else offered any opinion about what these provisions mean. I think
Would the course of operation of the different partnerships have something to do? In other words, whether in other occasions there had been consents, things like that?
There wasn't any such evidence either. That would be sort of the sort of evidence you might consider extrinsic. But I think really this comes down to the plain language, which is informed by the case law, the policies.
But counsel, the plain language also has to be looked at in context of the entire agreement. And there are other provisions in that agreement which suggest that there might be some ambiguity in the word transfer, whether it's a voluntary versus an involuntary.
But I think, yes, obviously you try to reconcile the whole agreement, and I think that's very important that we reconcile it here, because it's clear to me that Judge Duddy confused the admission procedures with the removal provisions, and he conflated the two. But the definition, the one phrase that Judge Duddy looked at was the word may. In my interpretation, which I put in the briefs, is that the word may is used to say a partner may, basically the same as requiring consent. May transfer his interest if, so the may comes with the word if, which is the same as saying you is a condition that you get consent before you transfer. So I think his interpretation, obviously you do want to interpret the whole contract, but I think my construction of it is I suggest the correct one.
Thank you.
Thank you.
Thank you, counsel. I'll echo Justice Meade's comment with compliments for the briefing and the argument here today on this issue. As is our usual practice, however, we will take the matter under advisement and issue a written decision in due course. With that, we'll be in recess on this matter.
All rise.
Seated. So the matter before the court is Kennebec 23419, Aubrey Armstrong versus the State of Maine. I see counsel are present. I'm assuming ready to proceed. I'm going to ask you to please introduce yourselves for the record by saying your name together with the party that you represent, starting with the appellant.
Good morning, Your Honor. Michelle King for the appellant Aubrey Armstrong.
Katie Sibley, State of Maine appellee.
Thank you. We are being streamed live on the web, both by audio and with video. And Attorney King, if you are ready to proceed, we'd be happy to take your argument, and you're welcome to bring the water up to the podium.
Thank you so much, Your Honor. Good morning. May it please the court. Michelle King again for Aubrey Armstrong. The law surrounding the issue of equitable tolling is fairly straightforward. It's a case-by-case analysis of two factors: whether the petitioner has been diligently pursuing his rights and whether there is some extraordinary circumstance that stood in his way of a timely filing. The diligence required is only reasonable diligence, not maximum feasible diligence. This case, Your Honors, is a complete mess. Mr. Armstrong filed a petition for post-conviction review on April 10th, 2023. What happened thereafter has denied Mr. Armstrong the assistance of counsel to properly frame his post-conviction claims and has resulted in no meaningful review of any of those claims. In his initial petition, Mr. Armstrong requested appointed counsel to help him formulate whatever claims he may have in his post-conviction petition. That petition was summarily denied on May 8th, 2023, without appointment of counsel. While summary dismissal is contemplated under Rule 70, this court has also cautioned that it's best practice for trial courts to appoint counsel so that worthy claims of post-conviction review are not lost. Mr. Armstrong filed a motion for reconsideration of the denied PCR, but it was never docketed in the lower court. However, we do know that that motion was received because it was denied on July 13th, 2023. Mr. Armstrong also filed a motion to extend time for an appeal of the denied petition for post-conviction review. That motion was also denied. In doing so, the lower court said that it had no authority to extend the time for filing a notice of appeal, that it was this court who had the only authority to do that. That ruling was erroneous because under Appellate Rule 2B, the trial court may extend such a time. While all of this was happening, Mr. Armstrong attempted to file a second PCR, but could not do so before the deadline. It's a sworn petition. It needs to be notarized, and Mr. Armstrong was unable to get it notarized before the deadline. That second sworn PCR was filed 1 week after the deadline of June 7th, 2023 to file an amended PCR. This case, I would suggest to you, is directly on point with the case of Ramos. In that case, a PCR was filed 15 days after the deadline. The court addressed both factors of equitable tolling and determined that Mr. Ramos had diligently pursued his claims and that there was an extraordinary circumstance that prevented him from filing his petition on time. In Ramos, the court said that desire and feasibility are not the same. Mr. Ramos desired to file his habeas corpus petition earlier.
I see the green is on. Can I just ask you a total side issue here out of curiosity? You said the petition must be notarized.
Yes, Your Honor.
Is that in statute or rule? I'm just questioning where that appears, the requirement.
I believe it's by statute, Your Honor.
We're going to suggest to you that it's actually not in the statute. However, I'm going to suggest to you as well that Rule 67 requires that the petitioner use the court form.
Thank you, Your Honor. I stand corrected.
And the court form has a notary portion.
It does, Your Honor. And,
all right.
and as a side note, I've had them rejected for failing to be notarized. So
Gotcha. Thank you.
it's upheld.
Didn't mean to interrupt your train of thought.
No, that's fine, Your Honor.
Could-
With respect to the claim that he was denied appointed counsel in a timely fashion, he filed his first petition on April 10th.
Yes, Your Honor.
The court acted on that petition within 4 weeks.
Yes, by May, yes, it did, Your Honor. I might add, without an opposition by the state. So it was summarily denied, no opposition by the state, no appointment of counsel.
But what I'm trying to get at is, what's the essence of the delay claim here for appointment of counsel? Is it that counsel should have been appointed before April 10th to help him prepare that petition? Or is it that once the petition was filed, counsel wasn't appointed in a timely fashion?
It's the latter, Your Honor. I would suggest to you, certainly the court would not know to appoint counsel before a petition has been filed.
Correct. Right.
But in this case, Mr. Armstrong specifically requested that counsel be appointed to help him file an amended PCR claim because he was unable to ascertain
But
what
under the
claims he may have.
PCR rules, I mean, the procedure that was followed here, i.e. a review for summary dismissal, which is essentially like a 12B6 review, occurs before the appointment of counsel, does it not?
It does, Your Honor, and as I started out saying, the rule does contemplate that that's allowed. However, again, in a number of cases, this court has said, Smith and McEachern in particular, that the best course of action when a PCR claim comes in is to appoint counsel and allow the petitioner to have counsel help them file an amended petition.
Do you agree that the petition, the first petition that was filed on April 10th, did not on its face raise a cognizable claim for PCR?
Yes, I do, Your Honor.
And under Rule 70, of course, it is standard once counsel is appointed to have the petition amended.
It is standard to have the petition amended.
Should the second petition that was filed have been considered an amendment to the first petition rather than a new petition?
It could be labeled an amendment, Your Honor, but it was also done without counsel. So again, a number of times during that process in his motion for reconsideration, he again asked for appointed counsel.
Well, can I go to the motion for reconsideration? I think you filed a copy of a motion for reconsideration, and as you indicated, there was no motion for separate motion for reconsideration docketed in the first PCR file. I've reviewed the original file. It's not only not docketed, there is none there. There is only the motion for enlargement of time that also sort of references reconsideration.
Correct, Your Honor. So that's part of why I suggested this case is a mess. The lower court clearly believed that there was a motion for reconsideration in play because if you look at the record,
well, was it just considering that the motion for enlargement of time was also a motion for reconsideration?
I would suggest not, Your Honor. There's a separate paragraph that addresses the motion for reconsideration in addition to the motion to extend time for filing an appeal.
Well,
separately
he had
discussed.
filed a letter. He filed three things on that initial submission. He filed a letter requesting reconsideration. He filed a cover letter, and the cover letter to the motion for extension of time or enlargement of time. So I think my reading of the docket record is the clerk looked at the letter and docketed it as motion, other motion. And that's what the judge acted on in his May 8th order. But I want to turn to the second petition. Mr. Armstrong was able to effectively identify cognizable ground in his second petition without the assistance of counsel, was he not? He identified ineffective assistance of counsel several times. Of course, all of that relates not to the preparation of his PCR, but to his trial and an appeal from the trial. But my point is, after the deadline, he files a second petition, and we have said you only get one bite at the apple on PCR. That second petition identified cognizable grounds. Why couldn't he have identified cognizable grounds prior to the expiration of the deadline, his first petition?
Yes, Your Honor. I know that There's a lot of things that happened in this case that aren't in the record. I could try to tell you what I understand, but it's not in the record. And I think that's part of the problem, is that the way this case came about, and Mr. Armstrong, on a number of occasions, at least in his memorandum to this court, asserted that he tried to have conversations with counsel, he tried to get help, and so in between the period of filing his first PCR and his second PCR, although he was not appointed counsel, I can't say whether he received somehow some advice from somebody else. I can't say.
Can I address the issue
It's simply
of-
not in the record.
Is the equitable tolling, even if we were to agree with you as a general principle that equitable tolling could apply, does the petition have to at least have on its face some grounds that would raise the issue of equitable tolling? I think it's the state's position that it doesn't raise that at all. And it doesn't. It doesn't say anything in the petition. It's only on this appeal that there have been some suggestions made as to why it should be tolled. Isn't that essentially waived at that point then, if it's not raised in the petition?
Well, again, Your Honor, I know that we try to hold pro se litigants to the same standard as lawyers, but I would suggest to you that requiring a pro se litigant who has limited reading capabilities of understanding the concept of equitable tolling, or that
He
it's
could have
even...
just said, it took me a while because I couldn't get it notarized.
That,
Excuse
Well-
it, he has a way, he certainly does a lot of this. I mean, you know, excuse it being late, I couldn't get a notary.
well, again, Your Honor, there's information that's not in the record. I have affidavits from Mr. Armstrong that are not in the record that say exactly that.
Do we need
But,
to remand? Do we need to remand this to the trial court to make a record? I mean, we're struggling with what is and what isn't here. Do we need to remand this?
I
to
would
get a full
suggest that
record?
that's the exact remedy here, Your Honor. You remand it, you allow Mr. Armstrong to have counsel who can help him through this process, make the record as to whether or not there's equitable tolling or not, and then we can at least have a meaningful discussion.
But the grounds that you've articulated throughout this argument have been basically he didn't know what he was doing because he didn't have a lawyer. That's not a ground for equitable tolling, is it?
That's not exactly the argument I'm making, Your Honor. For due diligence, the argument I'm making is he has filed a number of things. They've been unsuccessful, but
Well,
from
the time crunch here is due to the fact he didn't file his first petition until 10 months into his 12-month deadline.
Correct, Your Honor, but again, the record in front of you is devoid of the fact, although if you consider the memorandum that he filed with this court that talked about the numerous times he tried to reach out to his attorneys, tried to reach out to courts, tried to get the trial court record, tried to get his documents from his attorneys, all of those things, which he did put in his memorandum to this court, suggests that from essentially 2 months after the point in which his conviction was affirmed on appeal, he did start that process.
Do you agree that we apply the same standard for equitable tolling as the federal courts apply for habeases?
I do, Your Honor, and that's why I've cited a number of federal cases.
And do you agree that the ordinary delays of being in restraint in prison are not grounds for equitable tolling?
I do, Your Honor, but I would suggest that having a caseworker who can't notarize a document for 2 weeks is not the ordinary course that's conducted in a business.
So there's something, he shouldn't have known that it takes a long time to get a notary when you're in prison?
I think a 2-week delay is something that was not anticipated.
Are you suggesting there's a problem with Rule 70 to the extent that part of this issue seems to be that it took him 10 months to file his first petition because he didn't have the assistance of counsel? He didn't raise claims that were cognizable that would have warranted the court investigating the appointment of counsel.
I would love to suggest that there's a problem with Rule 70, Your Honor. I'm not sure this is the right place for it, but that rule is definitely like.
I.e. that there be appointment of counsel even before it's reviewed.
Correct, Your Honor. Are there no further questions? Thank you.
Attorney Sibley?
also have my water
You
too.
may.
Thank you, Your Honor.
I have cough drops if anybody needs them.
We have some as well. Thank you, Chief Justice Stanfill, and may it please the court. The PCR court committed no clear error by summarily dismissing Mr. Armstrong's second petition for post-conviction review. Title 15, Section 2128-B1 plainly states that there is a one-year limitations period for filing a state petition for post-conviction review, and that failing to adhere to that filing deadline constitutes a waiver of grounds for relief. The face of Mr. Armstrong's petition affirmatively discloses, with no exception or explanation, that his petition failed to adhere to that filing deadline. Under Rule 70b-2, as has been pointed out by this court, the PCR court shall summarily dismiss under those circumstances. Additionally, this court should not consider the issue of equitable tolling because it has been raised for the first time on appeal. Thus, the proper foundation has not been laid. But even if this court were to consider it, there is no evidence in the record to conclude that equitable tolling applies to this petition. Happy to take questions.
Well, you said there's no evidence in the record that it applies, but there's no evidence in a record at all. I mean, there was never a hearing. Isn't that really kind of the issue that Mr. Armstrong is arguing for, is at least that let him try to make the case that equitable, it may not be successful at it, but that he should be able to at least make the case?
Well, he had the opportunity to make the case. As Your Honor pointed out before, he could have submitted a letter with the petition and explained to the court, hey, I started this then, I couldn't have the notary come in, could have had the notary sign a letter saying, hey, yes, this is true. He had the opportunity, he didn't do it.
Or he could have said in his first petition, I'm handicapped because I don't have assistance of counsel in preparing this petition.
Correct. Now, whether, as Your Honor pointed out, that would be successful, likely not, as most of these petitions are filed without the assistance of counsel. It's only when cognizable grounds have been raised and it's assigned to the docket that the court appoints counsel.
Right, but there's some suggestion here that he had made a number of efforts over a period of time prior to filing that first petition to obtain some advice.
Again, there's no actual evidence in the record that that's what occurred. But
Is that a suggestion? There's a suggestion in the record.
Even if we assume that suggestion is correct, there's no explanation as to why he needed that information, and his first petition really belies the notion that he had to send all of those letters and try to get that information, because many of those issues he raised were raised in his prior appeals. He was aware of them, so there's really no explanation as to what he gained from that communication.
But doesn't that actually just point to the fact that without counsel, he's a little bit stymied on how he should raise the issues that he wants to raise?
I mean, not necessarily, Your Honor, as many of the federal circuit courts have pointed out, pro se status and quote-unquote ignorance of the law are not extraordinary circumstances. These are circumstances that apply to almost everybody in Mr. Armstrong's
What
position.
about if it is actions by the court itself that essentially stymied his efforts? In other words, I'm fairly concerned here that he files his first petition 4 weeks late, with 2 months to spare, which should have been enough time. It takes us a month, and I'm not saying that that's extraordinary, but nonetheless takes a month before that is summarily dismissed. We know that some weeks later he files a motion to extend the time to appeal and is referencing a motion to reconsider that no one can seem to locate, and yet the judge has an order saying motion to reconsider denied. And so then the judge also says, well, I can't enlarge your time to appeal, which is actually not accurate. It feels like he got stymied by the court at every step, and I'm not sure what happened. Should there at least be a hearing to find out?
I do find the lack of docketing interesting, and I wish I could represent to the court that that's the first time I've come across something like that. But it seems implausible that he could have relied on the court's July order to his detriment, because it was issued over a month after his filing deadline had passed.
Well, and it was issued, that July order was issued after he had already filed a new petition, which also, as I say, could have even been considered an amended petition. And the second petition clearly does raise cognizable grounds, but for the time, et cetera. But my question really is, when we start talking about extraordinary circumstances, actions of the court are actions that are beyond his control.
The time crunch here, Your Honor, was created by Mr. Armstrong. He waited 10 months into his 12 months limitation period. It's just like the ordinary course of mail isn't an extraordinary circumstance. I would argue that a lot of the court operations aren't either.
Well, certainly the taking a few weeks, because it actually doesn't go straight to a trial judge to review. It goes to the Chief Justice, who then assigns it, et cetera. But I'm not saying that. I'm just saying all added up. Between the telling him he can't appeal that one, I can't give you more time to appeal, you can't, et cetera. It just does feel like he got a little stymied by the court.
Yeah, the court saying that couldn't it extend the time when the rule clearly states they can. I can understand where Your Honor is coming with that, but even if we're going to consider equitable tolling, we're going to have to start with diligence before we get to these extraordinary.
Right, but we don't have a record, is the point on the diligence.
Correct. I'm going with the suggestion as to what happened, but what we have in the record on the face of it is he waited 10 months into a 12-month limitation period to start the process. So
one would never have to reach equitable tolling at all if everybody filed it 1 month into the 12 months, right?
Well, it could make things easier, but that's not probably not realistic.
As a realistic matter, the equitable tolling issue arises because people file later in the process.
Correct, Your Honor.
And so that in and of itself does not mean that there may not have been due diligence in this case, don't get me wrong.
Right,
but my question really is, shouldn't there at least be a factual record with findings to make these determinations?
Certainly, that would be preferable, hence this court's longstanding precedent that the foundation be laid in the trial court for appellate review, but the burden was on Mr. Armstrong to create that record. As Your Honors have pointed out with the questions, there were things he could have brought to the court's attention that would have maybe highlighted for the trial court, brought to the trial court's attention, and the trial court may have agreed with him and said, okay, I'll accept this, but Mr. Armstrong didn't do any of that.
Well, I may be missing something here, but Mr. Armstrong had two requests. He requested a motion for reconsideration, and he requested extra time to file an appeal. Now, I maintain, by looking at the docket record, that what the clerk did was docketed his letter requesting reconsideration. It didn't have attached to it a separate motion, at least as I've seen in the record. I think that was docketed as motion-other motion, and then beneath that was docketed motion for allowance of extra time. I think the clerk docketed both of those entries on May, 2 weeks after the receipt of the April 10th, around April 24th or April 25th. The court acted on that motion for reconsideration within another week or two. The May 8th order was a denial of the motion. No, I'm sorry, that was the denial of the petition. Subsequently, had denied the motion for reconsideration. As for the extra time for appeal, he has an appeal. We're taking his case up here.
Regarding the second petition that he filed, not the first, but I believe his motions, the motion to reconsider that has disappeared, or at very least the letter and the motion to reconsider, I believe were both filed after the limitations period had expired, because it was in response to his receipt of the court's May order.
In an ideal
if I have my
world,
timeline correct.
In an ideal world, he would have filed his first petition, and it would have been rejected as not stating anything to which he's entitled PCR. He would have received that, immediately filed motion for reconsideration or a motion to procure counsel. That would have been acted on immediately. counsel would have been appointed, and an amended petition would have been filed with cognizable PCR stuff. Ideally, that would have all happened in a period of like weeks, but of course it didn't. Bumped up against the deadlines there, and you can presumably understand the discomfort that some of the members of the court have expressed, saying, well, here's a guy who actually did start the process months ahead of time. Things happened in the meantime, so that some of the delays may have been the result of him, and others were totally beyond his control. And I guess I'll just ask, do you recognize, do you acknowledge the fact that there's some discomfort not knowing exactly the timeline of what happened and who was responsible for the delays of leaving him hanging out there without counsel?
I absolutely can understand the court's discomfort. I mean, I think it's why this court typically does not address issues for the first time on appeal without the record. But again, it was on Mr. Armstrong to bring that information to the trial court. He did not do that.
Well, and I'm looking at the times. The first one is dismissed on May 16th, and he receives it on May 25th. He knows his deadline is coming up, so it's 6/7. He's got to do something fast. He doesn't file his motion to reconsider, if we treat that as the letter, and his motion to enlarge until 6/20 and 6/21 past the deadline. So where is the extraordinary circumstance that we're to rely on for narrow equitable tolling?
My argument, Your Honor, is that there are no extraordinary circumstances here. He knew his deadline was coming, just as the court pointed out. Even if we take his suggestion that he started initiating the paperwork on June 2nd, he waited nearly a week and within 5 days of the deadline, and then waits even several more weeks to even address the first petition, as Your Honor pointed out, filing those motions after the expiration of the date. Those aren't extraordinary circumstances.
And when we look at the narrow grounds that the federal courts apply for equitable tolling, it's usually something that's very affirmative. Somebody lies to the prisoner. I mean, can you identify any situation where it's a delay? I don't have a lawyer. I can't get to a library. It's taking a long time to get a notary. Do these fall into conditions out of the control of the prisoner that have been relied on as a basis for equitable tolling?
In the circumstances of this case, Your Honor, I would say yes, those fall into the category of things inherent with custody. He knew that a notary was not readily available. You can look at the dates on his first petition as to when he signed it and when it was notarized. He knew there would be a delay, and he delayed further. Now, there could be a circumstance where either trial counsel or a court, when something's filed, makes a misrepresentation that impacts what an individual does. There potentially could be a circumstance in custody that would qualify, which is why, when we're talking about equitable tolling, it's done on a case-by-case examination. In what we have in this case, I would argue, is neither diligence and not extraordinary circumstances.
We also have a statute that tells us when waiver occurs. And it says you're supposed to raise all grounds in a single PCR, and if you don't, there's a waiver, unless the Constitution requires or the court determines that the ground couldn't reasonably have been raised in an earlier petition. Is there a reason why ineffectiveness of counsel or prosecutorial misconduct couldn't have been raised in the first petition?
I believe they were, Your Honor. I think it's ground 2 of the first petition where he discusses prosecutorial misconduct and inducements. But again, those were all issues that either were.
But he didn't allege ineffective assistance in the first petition.
Correct. When I look at the two petitions side by side, they're actually pretty similar. If you look at what he writes as the factual basis, but he just writes ineffective assistance of counsel. Ground 3 of the second petition, I think, is a cognizable ground because it's alleging ineffective assistance I believe in his first appeal, not raising the sufficiency of the evidence argument, and sufficiency of the evidence was not raised. I believe that's this
So I think
point.
Justice Connor's question is, are you able to identify any reason why he could not have simply said ineffective assistance of counsel in the first petition?
I am not, Your Honor.
Did I get that right?
Yes. I apologize for misunderstanding your question, Your Honor.
Thank you. And Ms. King, isn't that really the challenge here? Prisoners file these all the time, and they know the magic words are ineffective assistance of counsel.
I think that's true under ordinary circumstances, Your Honor. But if you look at the case of Hudson, it talks about limited education as a factor. In this case, at least in his memorandum to this court, Mr. Armstrong has suggested that he has low reading capabilities. And so I would suggest to you that that's one of the factors that should be considered when determining whether or not he was able
It could be, but the reality is that his filings in the trial court as well as to this court, frankly, are more articulate than many we receive.
Fair enough on that front, Your Honor. To address Justice Connor's earlier question about whether or not there are cases on point, I would suggest to this court, in addition to the Hudson case that I just noted, the Ramos case, which I spoke of earlier, does quite a very good job of analyzing due diligence as well as extraordinary circumstances. And in that case, the court said that there are a number of factors that did lead the court to believe that Mr. Ramos was exercising due diligence, including that he was in state custody, he had no attorney, he had opposed motions, and for years he had been trying to exercise his rights. And I would suggest to you that that's the same here for Mr. Armstrong. He took a number of steps. He didn't sit around doing nothing, and then one fine day on June 21st, he tried to file a motion. He took a lot of steps along the way to try to exercise his rights, and was stymied by the courts and their ineffectiveness. So given the torturous nature of this case, I would suggest that the only remedy is to remand this case, appoint counsel to Mr. Armstrong, so that we can perfect a good record.
So next time you may have to reserve 2 minutes for rebuttal.
Indeed, I'm still learning, Your Honor.
Thank you, counsel. Thank you, as always. And we will take the matter under advisement and issue a written decision in due course. Thank you.
All right.
And you can be seated. The matter before the court is York 2468, State of Maine versus Calixte Fleury. And counsel are present. If you would identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Michelle King for the appellant Calixte Fleury.
Good morning, Kyle Miska for the State of Maine, appellee.
Thank you. We are being streamed live on the web, both with video and with audio. And Attorney King, if you're ready to proceed, we'd be happy to hear your argument.
Good morning. May it please the court. Michelle King for Calixte Fleury. 14th Amendment instructs that no one can be deprived of liberty without due process of the law. Here, Mr. Fleury was denied substantive due process because application of the statute in effect at the time of his arrest, which was subsequently amended before his trial, violates the decency of civilized conduct. It allowed for a criminal conviction for trafficking with scant evidence of trafficking, as that term is commonly known. It places him in a position of being convicted of trafficking in fentanyl because he was arrested prior to October 18th, 2021, versus someone who was arrested after, even if they were tried and convicted at the same time. That outcome violates due process in a way that shocks the conscience. Substantive due process imposes limits on what a state may do regardless of what procedural protections are provided. It bars certain government actions regardless of the fairness of the procedures used to implement them. It serves to prevent the government from being used for purposes of oppression.
Counselor, do you agree that in the abstract, it's okay for the legislature to make a criminal statute more lenient only prospectively?
I do, Your Honor, and it is clear from this record that the legislature didn't intend for it be applied retrospectively.
And so it's not a violation of ex post facto or any other provision for that abstract. They aren't going to apply it retroactively.
I would agree with that, Your Honor.
So what is it about this case that takes it out of that general proposition and makes it a due process problem?
Well, when we look at due process, we look at not only a factual challenge, but we look at it as applied. And again, if you look at Mr. Fleury's circumstances, the timing of his arrest, the timing of the indictment, the timing of when this bill was filed, it suggests a modicum of unfairness. And I understand if we look at the statute and whether or not it's retroactive, technically speaking, there's no violation.
What is the difference then between this case and State versus Tripp, where there was a change in the Good Samaritan law that would have given the defendant in that case probably a complete defense, and we said it doesn't apply, it's not retroactive. Why is that not governing in this case?
Well, sadly, Your Honor, I think it probably is governing in this case.
Fair enough.
But I'm standing here with what I have.
I understand, and we appreciate that. Can I ask you a little bit different question? The challenge you're raising is really only to count one, is that correct?
I'm sorry, I didn't hear you.
The challenge you are raising is really only to count one in any event, is that correct?
Yes, Your Honor.
And in this case below, it looks like counts 3, although the docket doesn't reflect this, on the actual judgment and commitment, it appears that count 3 was merged into count 2.
I would agree with that, Your Honor.
Shouldn't count 2 also be merged into, shouldn't they all be merged into count 1?
I believe the sentences were
They were concurrent, but they're still separate convictions.
Right. That's an argument I hadn't contemplated, Your Honor.
Okay, well, I guess that I'll save that question then for Mr. Miska as to whether they should all be merged.
Did I understand you, in your previous comments that you were suggesting that the temporality is a factor that should be considered in the unfairness? In other words, the date of his offense and the date of the amendment? And if they're close together, that is a factor that we would look at in the big picture as to whether or not we should apply the arguments that you're making here today.
Well, when you're looking at the big picture, Your Honor, in fairness, I do think you have to look at the circumstances of each case. That's why it's called as applied substantive due process. It's not looking at everybody as if they stand on in the same circumstances. And here, the temporality of it is actually quite close. So the arrest happened in September of 2020. Mr. Flory was indicted on April 6, 2021. The bill was filed on May 3rd, 2021, so within a couple of weeks there, and then the bill was amended and adopted such that it took place on October 18th of 2021. Now, Mr. Fleury's trial didn't happen until 2024.
What is to distinguish, though, this case from any other case in which a law is passed or the statute is amended, any other criminal case in which the statute is amended to provide for lesser penalty or to decriminalize something and yet not made retroactive? I mean, aren't you essentially arguing for a rule that would apply to all cases where charges are pending at the time of amendment?
Well, I'm not asking for a rule that applies, a bright line rule that applies to all cases, Your Honor. I'm asking that you look at this case on a case-by-case basis.
Right, but I'm trying to understand what it is about this case that would make it different from the next case to come along when, you know, a statute is amended to make it more lenient.
So if we buy into it here and this is the timeline for this case, and we say, yep, you've got it, and then somebody comes, okay, my timeline's a little bit longer, aren't we sliding down a slippery slope of uncertainty there that we would end up creating a bright line at some point saying, oh, well, this was X weeks and that was Y weeks. This one qualifies, this one doesn't. That's what I was getting at in my original question.
And as one of our colleagues used to say, tell me what the holding of the case would be.
Well, as in all cases, case-by-case analysis, Your Honors, that's the difficult decision about where each case falls and how that's analyzed and where the decision comes. And looking at, I believe, Justice Stanfield's earlier question about whether it relates to sentencing or the substantive part of the law. In this case, we're talking about a conviction on a case for possession of an amount of drug that's 2 grams. And 2 grams or more.
Or more.
Yes.
Quite a bit
more,
more,
2 grams.
actually.
Well, no, I mean the statute, Your Honor, not
Okay. I thought you were suggesting he was only possessing.
Oh, no, Your Honor. He possessed 18 grams of fentanyl plus another, I believe, 6 grams of fentanyl tablets. So it's a total of 20.
In terms of fairness, doesn't that suggest that at the time that the conduct in question took place that resulted in the offenses being charged against him, presumably he is supposed to have knowledge of what the laws are in the state. So how is it unfair? To the extent that when he was acting, the statute in place had this as a defined violation of the law in terms of possession or trafficking, to be precise.
Right. He certainly is held to the accountability of knowing what the laws are at the time, Your Honor. But again, if you look at substantive due process and you compare the fairness of somebody who was arrested in the same time period or maybe just months apart and had a trial at the same time to have somebody convicted of trafficking and yet another person convicted of mere possession and the sentence of that being significantly different, I would suggest when you look at the overall fairness of it.
And I'm still looking for what the rule of law is as opposed to it's just not really fair.
Let's look at this in a slightly different way because we have 4.5 minutes. The legislature changed the law essentially because they thought it didn't make sense to assume someone is trafficking with only 2 grams. And the judge in this case said, I'm not doing forfeiture because there's no evidence of actual trafficking. So is there an argument here that the statute at the time that it applied to him was irrational because of the subsequent legislative activity and the finding in this case?
Well, I think that's implicit at maybe not quite as clear as it could have been in my argument that I made in my brief, is that in applying a trafficking charge, if you think of it in the common term of trafficking, is to sell, to manufacture, to do things like that. But the statute that was in place at the time that Mr. Fleury was convicted allows for a trafficking charge for possession.
Okay, so here's my next question. That argument is a little more, has more legs if he only had a very scant amount of drugs.
Like actually 2 grams.
Yeah, right. Can he, because he had significantly more drugs on him than that, is he still in a position to argue against the unconstitutional, like a facial claim against the statute, even though as applied, it might have a more rational basis to conclude he's trafficking?
Well, actually, I think my argument on that front has a little bit more teeth. In this case, although he did have 18 grams of fentanyl, there was no other evidence of trafficking. There were no baggies found, there was no scale found, no ledger found, there was no direct evidence of drug activity. We have nothing but the amount. And we do have $908 that was found on Mr. Fleury, but there was no testimony from the officer tying that particular amount to any type of drug activity, no testimony that the denominations that were found could be linked to drug activity. There's essentially nothing except the amount of fentanyl found on...
Which is why forfeiture was denied, correct?
I'm sorry?
That's why forfeiture was denied, correct?
Correct, Your Honor.
But that amount would have been, or could have been enough to convict him of possession with intent, trafficking based on possession with intent to distribute, which remains in the statute, right?
A permissible inference, Your Honor, that can be overcome by other evidence or lack of other evidence with regard to...
The amount and the amount of the contraband and the amount of the money could justify a jury verdict convicting him of possession with intent to distribute, irrespective of the 2-gram amount, correct?
Unfortunately, we won't know that because the jury was instructed that all we needed to have in this case was possession of 2 grams or more. So had the jury been instructed differently, that they could have considered a permissible inference and all of the other evidence of or lack of evidence with regard to trafficking, we would be looking at a different situation. But the jury was instructed that all the state needed to show was 2 grams or more.
And possession with intent to traffic is not a Class A aggravated trafficking carrying a mandatory minimum 4-year sentence.
Correct. If there are no further questions.
It does appear to be. And Attorney Miska.
Good morning, Your Honors. Chief Justice Stanfill, may it please the Court. Calixte Fleury was convicted of aggravated trafficking in scheduled drugs, unlawful trafficking in scheduled drugs, possession, and OUI for conduct he committed on September 18th of 2020. On October 18th of 2021, some 13 months after his criminal conduct was committed, a statutory amendment went into effect, changing one of the definitions of trafficking under Maine law. Essentially, Title 17A, Section 1101 was amended, removing the definition of trafficking, which is to possess 2 or more grams of fentanyl. Importantly, the legislature did not include any additional language when it made this particular amendment. The reason that's so important is the Court has already keyed in on Title I, Section 302 specifically states, and I quote, "The repeal or amendment of an act or ordinance does not affect any punishment, penalty, or forfeiture incurred before the repeal or amendment takes effect." Section 302 further states, "Actions and proceedings pending at the time of the passage, amendment, or repeal of an act or ordinance are not affected thereby." In January of 2024, this Court had the opportunity to apply that statute in a criminal case. There, in State v. Tripp, as the Court has already noted, there was a defendant who was claiming Title 17A, Section 1111B, which would provide him with a certain amount of immunity for certain conduct, was amended while his case was pending, and that he should have the benefit of the amended statute, which would grant him with greater immunity, applied in his case. However, this court stated that Section 302 provides a general rule of construction which is controlling absent clear and unequivocal language to the contrary. There, the legislature included no such language in the amendment to 1111B, and because it was held that in a criminal case, punishment, penalty, or forfeiture is incurred specifically when the conduct or crime is committed, the appropriate statute to apply was the one in place again at the time Tripp's conduct was committed. Likewise here, Mr. Fleury's conduct was committed on or about September 18th of 2020. The statutory amendment did not go into effect until October 18th of 2021. That subsequent October 18th, 2021 amendment did not indicate even an intention to make that amendment apply retroactively. That's the only way that Section 302, which is a general rule of construction, can be overcome, and therefore application of the amended statute in Fleury's case is absolutely barred. Furthermore, this court in Tripp found that it wasn't even necessary to consider whether or not Tripp's constitutional rights were violated by application of the retroactive law, or by retroactive application of the amended law, because the appropriate law to apply was in fact the one that was in place at the time of his crime being committed. Now, this holding highlights an important distinction before the court today. Fleury, just as Tripp did, is trying to claim that his constitutional rights have been violated by not applying the amended law, but that's not the appropriate analysis. The appropriate analysis instead...
Well, let me ask this question. Do you think that there is some minimal level of possession of a controlled substance that it would be irrational to presume that definitively that the person who is possessing it is engaged in trafficking?
So if I may just clarify, you're asking at what level?
Is there a level at which, if you had a scant amount of drugs on you, that it would be irrational to definitively presume that you're trafficking?
Well, I wouldn't say the amount to be scant. I would say there is a certain level where, yes, at a certain level.
Okay.
It's really not rational to assume they're trafficking.
Yes, Your
at a
Honor.
certain level.
And do you think that 2 grams, I mean, the legislature subsequently said it didn't make sense, and the court here found there was no other evidence of trafficking. So was the statute, before it was amended, can it be argued that it was irrational?
Well, first and foremost, there was testimony by Sergeant Thomas Pappas with Maine State Police that in his training, education, and experience, the 20-plus grams of fentanyl, as well as $908 in cash.
I know he had more than 2 grams on him.
Yes, Your Honor.
So that raises the separate question of whether he could properly raise a challenge to the statute itself that only required 2 grams. And I'm asking the harder abstract question about the 2 grams. So is it rational to presume that someone who has 2 grams on them is trafficking?
Your Honor, I would say that it is a difficult question to answer simply because the drug world has been evolving. So when I first started doing this, when I used to see people who were in possession of 5 grams or 10 grams, that was a very significant amount of drugs. Nowadays, we're seeing people, unfortunately, with greater and greater quantities because it is more and more available. And I do think that there was a rational tie to the legislature's initial law, the one that was in place at the time of Fleury's conviction, because the government was trying to combat the overwhelming spread of fentanyl in the state. It's a disease that unfortunately claims all too many lives in the state, so I do think that there was a rational component there in saying that at a certain level we are going to presume trafficking.
But interestingly, that was not, well, the way the statute was, it was a conclusive presumption really for a jury. In other words, if there was 2 or more grams, it
Yes, Your
was
Honor.
trafficking. Section 1103, subsection 3 has various provisions in which it is at least possession of a certain amount of different kinds of drugs can be evidence of trafficking, essentially.
Yes, Your Honor.
But they didn't, when they repealed the 2-gram definition 2 grams of fentanyl being of possession being a definition of trafficking, they didn't then add, but it could be considered. And they didn't seem to amend it to add any presumption like that or any inference for possession of fentanyl. Am I right?
No, Your Honor, there's actually a permissible inference for trafficking in fentanyl and heroin. Specifically, that amount was changed, so it's no longer 2
Okay.
grams, it is 4 grams,
Uh,
if I recall the statute correctly.
Okay, I guess I'm just
It might be
missing
the most recent iteration that
Okay,
the
I may
permissible
be
inference
missing
is
it.
at 4
Can
grams.
I ask a different question?
Of course, Your Honor.
The question that I asked Ms. King, in this case, it's my understanding that the court ordered count 3 merged into count 2.
Yes, Your Honor.
The docket doesn't reflect that, by the way, only the judgment and commitment does. But why shouldn't they all be merged into count 1?
Your Honor.
Assuming we allow count 1 to stand as it is.
Yes, Your Honor, and the way I would explain it is this, is the state's theory rested upon 2 different baggies of fentanyl that were found on Mr. Fleury.
There's the pills plus the baggie.
Correct, Your Honor. So the aggravated trafficking charge, and this was made clear at sentencing, was based upon the 18-gram bag that was found on Mr. Fleury. There was an additional bag of 53.5 pressed
But even
pills.
if there's 2 different theories, when we talk about merger, don't we look at how the elements and the charge? I mean, I don't see how as charged, if he's found guilty of count 1, that doesn't mean he also, how he could not have also committed count 2.
I would agree, Your Honor.
I mean, it doesn't change the sentence necessarily. It's a question of how many convictions there are.
Correct, Your Honor, and I would say that under the circumstances, the state's theory was that the pressed pills, only a few of those pills were tested according to the HETL Labs 9550 testing policy. So under the circumstances, the state went forward on the unlawful trafficking in the alternative.
I understand why it was done. I just
Yes, Your
the
Honor.
question is, having found him guilty, the jury having found him guilty of all of those counts, including trafficking, actual trafficking, so which makes the forfeiture ruling somewhat curious.
And I can speak to that if you'd like, Your Honor,
No,
but in
it's
the
like-
grand scheme of things, I do think that the second conviction could absolutely be merged with the first.
Okay. So you wouldn't object to having them all merged into the 3 drug cases being merged?
Correct, Your
into-
Honor, and I think that at sentencing, there was a lot of discussion regarding the danger of pressed pills in particular.
I understand.
So under the circumstances, I don't think it would change the sentence whatsoever, just as you stated, the convictions for which he was found.
Okay, thank you. There don't appear to be additional questions. Thank you.
Thank you, Your Honor.
And Ms. King, I don't know if you needed 2 minutes of rebuttal in this case.
It's going to be a slow process of my figuring out what to save and not to save, Your Honor, and whether to save any at all, but I'm taking it each case as it comes. Mr. Fleury's substantive due process rights were violated when he was convicted and sentenced on trafficking in fentanyl with no evidence of trafficking as it's commonly known at all. And I would suggest to you that this court should vacate his convictions on that front.
And I assume you have no objection to us ordering counts 2 and 3 both merged into count 1 if we sustain the conviction on count 1.
I'd be delighted, Your Honor.
Okay.
Thank you.
Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a decision in due course. Thank you.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as a law court, may hence depart and give their attendance at Bideford